Have you ever watched a police show where they yell, "We've got probable cause," before making an arrest and wondered what that actually means? Can police really decide that on the spot? And what if they get it wrong? Well, that phrase, probable cause, is one of the most important protections built into the US Constitution. It's the line that separates a lawful arrest from a violation of your rights. Probable cause means there are reasonable grounds to believe two things. One, that a crime has been committed, and two, that the person being arrested or the place being searched is connected to that crime. It's more than just suspicion, but less than absolute certainty. You don't need proof beyond a reasonable doubt yet. That standard comes along later if a case goes to trial. In this stage, police just need enough reliable facts to justify taking action. So think of it like a puzzle. There are enough pieces in place to see the picture forming, even if it's not finished yet. Without probable cause, any arrest or search can be challenged, and any evidence found might be thrown out in court. It's what keeps police from arresting people just because they feel like it. The Fourth Amendment to the US Constitution, the one that protects against unreasonable searches and seizures, was written for exactly this reason. So let's dive into some real-life examples. So let's say an officer pulls somebody over late at night because they were weaving. Well, that's reasonable suspicion. But then, as they approach the car, they smell alcohol, see open beer cans in the cup holder, and notice the driver slurring his words. Now, those specific facts together create probable cause for DUI. That gives the officer legal grounds to arrest, perform a breath test, and get a search warrant if additional testing is needed. Let's give another example. Police get a tip that stolen jewelry is inside a specific home. Well, a tip alone isn't enough. That's just hearsay. But if the officer verifies the tip, maybe by checking pawn shop records, surveillance footage, or matching serial numbers, now they built enough factual evidence and they can take that to the judge, and the judge can issue a search warrant because probable cause exists. Without those verified facts, there's no warrant, no search, and that's how the system protects people from random or biased government investigations. So picture a line of dominoes. Reasonable suspicion is the first one. It starts the movement. And probable cause is the movement they fall far enough that action can be taken. Beyond that, well, you may reach the trial stage, which is beyond a reasonable doubt, and each level builds on the one before it. There are three main times police must have probable cause. Before an arrest, they must be able to explain what crime they believe happened and why the person arrested is involved. Before a search warrant, a judge won't issue one unless there's solid evidence linking a place or item to a crime. Before charging somebody, prosecutors must review the evidence and confirm there's probable cause to move forward with a criminal case. Now, courts look at what's called the totality of the circumstances, and that means all the facts viewed together, not just one detail. So, for example, the smell of marijuana plus visible baggies equals probable cause. An anonymous tip with no proof, that's not enough. Nervous behavior alone, without anything else, not enough. Multiple consistent witness statements plus a video, that's probable cause. So it's about patterns and credibility, facts that would make an average person believe that a crime occurred. If the police make an arrest or search without probable cause, well, the defense can challenge it in court through what's called a motion to suppress. If the judge agrees, then any evidence found gets thrown out, meaning the prosecution might lose their entire case. And that's why attorneys often say, if there's no probable cause, there's no case. Let's go into a third real-world example that shows why this matters. Imagine you're sitting in your parked car and you're texting. Police pull up and they say that you look nervous, and they arrest you after finding somebody else's bag of drugs on the ground nearby. Well, that arrest's not going to hold up. And why? Because looking nervous isn't probable cause. There's no direct evidence connecting you to the drugs. A good defense lawyer would challenge that and likely get it dismissed. Probable cause isn't just legal jargon. It's one of your strongest shields against abuse of power. It forces police to gather facts before taking away someone's freedom. And it ensures judges act as a check before searches or arrests happen. It's not about making police work harder. It's about protecting the innocent and making sure every case starts on solid ground. Here's where we're at as far as the pyramid of proof. Reasonable suspicion means police can stop or question you. Probable cause, they can arrest or get a warrant. And next, we're going to move into what happens after an arrest when your case goes to court and the state has to meet the highest standard there is. So if probable cause is what gets you into court, what does it actually take to be found guilty once you're in court? That's where we reach the top of criminal law, beyond a reasonable doubt. And in the next video, we'll break down what reasonable doubt really means and why it's the foundation of every fair criminal trial.